Good afternoon. I'm constitutional attorney Katherine Henry, and welcome to my first weekly show of the Restore Freedom efforts to fight for freedom here in the United States. And this is the first of our 2022 series of these videos. It is kind of with a little bit of excitement that I announced to you about the Detroit News versus the Independent Citizens Redistricting Commission. That is the title of the case. It was argued on December 15th, and it was decided only 5 days later, December 20th. And there's a reason for that, but let me do my best to give you the best about this. There's some of the basics about what happened in this case, which are very important to let you know about, but there's also the undertones and things that were said that have an impact on other cases. And then there's also, again, another aspect of the case where there's a different philosophy about the case. So this case, like I said, is the Detroit News versus the Independent Citizens Redistricting Commission. And in this case, the majority opinion was authored by Justice Viviano. He was joined by Justice Zara, Bernstein, and Clement. Clement joined in part, she also dissented in part. So the main aspects of this case, as described by Justice Viviano, in 2018, the voters of Michigan, supposedly, I'm still not believing it, chose to vest responsibility for redistricting not in its legislature as had been done for decades past, but in an independent, unelected bureaucratic body. The body they created is called the Independent Citizens Redistricting Commission. And throughout this opinion, they're just calling that body the commission. So I'll probably do that myself just for ease of discussion. The body consists of 13 commissioners, generally selected on a random basis from a pool of applicants. And you can find that part in the Michigan State Constitution, Article 4, Section 6, subsection 2. In placing, and again, these are the words of Justice Viviano and the majority, in placing the redistricting power with an independent body of unelected officials, the voters chose to ring the body with transparency requirements, forcing much, if not all, of the commission's work into the daylight. So to give you the little bit more of the background and understanding of what's going on, the plaintiffs are a group of news organizations and press seeking to enforce the transparency requirements of this new constitutional provision. And Justice Viviano makes an important note that in addition to the individual news outlets, the plaintiffs in this case include the Michigan Press Association, which is the official trade association for the various newspapers in Michigan, and its executive director. So the commission is, of course, charged with redrawing the redistricting plans for our state and federal legislative districts. And the language of the Constitution that says that specifically is State Constitution, Article 4, Section 6. The commission shall adopt a redistricting plan for each of the following types of districts: state Senate districts, state House of Representative districts, and congressional districts. Then Justice Viviano says that pursuant to that duty, the commission must consult with and provide information to the public. I mean, that seems really obvious, but that is the whole crux of this entire case. Before any drafting begins, the commission must hold at least 10 public hearings and receive materials from the public. Then, after developing at least one proposed redistricting plan for each type of district, the commission shall publish the proposed redistricting plans and any data and supporting materials used to develop the plans. That is Article 4, Section 6, subsection 9. So it says the first proposed plans were published on October 11th. So at that point, that's when all of the information that they had been reviewing, the supporting information, the data, and everything needed to be shared. What's interesting is that Justice Viviano points out in another footnote that it is worth noting that the dates do not conform. The dates that the commission did all this in Michigan this last fall and into the current time does not conform to the constitutionally imposed deadlines for the proposal or the adoption of plans, according to Article 4, Section 6, subsection 7. The commission even filed a previous lawsuit requesting authority to disregard these deadlines because of the delay in obtaining federal census data. But this court, meaning the Michigan Supreme Court, denied the request because we were not persuaded the requested relief should be granted. So it's interesting that the commission had this excuse for why they wanted to throw out the constitutionally imposed deadlines to do their job. And even though the Supreme Court said, no, you can do your job on time, the commission still violated the state constitution in that respect. And then they continued to violate it in several other respects. So one of the problems that the plaintiffs raised is that the commission voted to enter a closed session discussion on October 27th to consider 2 memoranda that came from their attorneys. They also had a series of, in total, 10 memoranda that they considered, but that they did not make public. They claimed that those memoranda were completely covered by attorney-client privilege, and so therefore they did not need to disclose that information to the public. So as the efforts were ongoing, though, the court points out that a bipartisan pair of legislators asked the Attorney General to produce an opinion on whether the commission violated the Constitution by conducting a closed session. Now listen to this. My props goes out to the Michigan Attorney General. The Michigan Attorney General, I don't know for sure if it's Dana Nessel herself or somebody that works for her, but I'm just going to give her the credit because it's her title that's on this. She did a phenomenal job. Now, granted, I didn't read her whole opinion, but I'm reading the parts that are referenced by this case and by these justices here. It says that the Attorney General concluded that the meeting needed to be open under Michigan Constitution 1963, Article 4, Section 6, subsection 10, and that the memoranda considered at the meeting needed to be published under subsection 9. And that was an opinion 7,317 that was issued on November 22nd. However, the commission was completely unfazed, as the word that was used by the Michigan Supreme Court here, by the Michigan Attorney General's analysis, and the commission continued to deny the public, and specifically here, the media, the requested information. So the plaintiffs filed the emergency action in the Michigan Supreme Court, which had original jurisdiction under subsection 19 of the section we've been talking about. So the plaintiffs didn't have to go to some trial court and then appeal and then maybe eventually work their way up to the Michigan Supreme Court. This was one of those things that gave the Michigan Supreme Court original jurisdiction so the plaintiffs could file this action right away, right with the Michigan Supreme Court, and not waste any time whatsoever, because the redistricting thing is kind of a thing that's happening like right now. So everything is very timely. Next, this case talks about, so they're talking about the whole battle is, does the attorney-client privilege protect the commission from giving information to the public? Are they allowed to hide behind attorney-client privilege and hold closed sessions and keep memoranda to themselves and keep, essentially information away from the public? And the overall opinion from the court, I'll tell you, that they said was no. Attorney-client privilege does not apply the same way to governmental bodies and agencies as it does to a typical private entity or client. So the court also points out that the court interprets the Constitution by the ordinary meaning of terms. And it might seem simple, but take that at face value. The court is supposed to interpret the Constitution by the ordinary meaning of the words. That's very important for every case. And they also point out that nothing in the text of the state constitution itself references any attorney-client privilege or protections that this commission or any government body would enjoy just, to be able to hide information from the public. That's not in the language of the Constitution. So to me, right then and there, the conversation should have ended. The discussion should have been over, and it should have been in order to immediately disclose all information to essentially undo what came out of the meeting on October 27th, and certainly to release the video or audio recordings from that meeting. But the court continues that attorney-client privilege is important. Okay, it is important because it allows people to be open and honest and candid with their lawyers. Lawyers have a job, they have a duty to be open and honest with the court and with opposing counsel. And that doesn't mean you have to expose all of your client's secrets and whatnot. But if you don't know the truth about things, if your client is hiding certain aspects because they're afraid that that communication is going to all get out in front of the court, then you can't do your job well as an attorney. I've had clients, totally blindside me when I, doing a custody case. I thoroughly vet the client, vet the situation. The client doesn't think there's something that they should tell me about. And lo and behold, we're in the middle of a trial or an evidentiary hearing, and something comes out where, dang, I could have done a lot better to represent their interests had I been given a little heads up that something might be an issue, even if it really is a non-issue. If I don't have the ability to know ahead of time that it's coming, I can't do my job. So attorney-client privilege is meant to help the attorney be able to do a good job in representing their client's interests. But it's not supposed to be the kind of thing that they can then turn around and use in a governmental setting to keep information away from the public. If anything, it's supposed to be used. In fact, the court really does a good job of explaining the purpose here. And I don't want to try to reinvent the wheel. I want to give you the court's own words on that particular point. So it basically talks about that there would be a radically uneven playing field in court if you had, one side was essentially able to go and learn about all the inner workings of the attorney-client information and conversations that were happening on the other side of the case. You need to be able to have those open and candid discussions with your attorney. That I agree with. That I would think everybody would agree with. What's different is when it's a government body. Certainly the biggest difference. In fact, this court quotes from initially an 1888 United States Supreme Court case, and then subsequently a 1981 United States Supreme Court case, but saying that although the attorney-client privilege is the oldest of the privileges for confidential communications, and it is founded upon the necessity in the interests and interest and administration of justice, of the aid of persons having knowledge of the law and skilled in its practice, which assistance can only be safely and readily availed when free from the consequences or the apprehension of disclosure, which is essentially the long way of saying what I just said to you. So I'm not going to restate that now. What's very interesting, I want to point out, is that there has been some other cases where people are basically told that they have to have an attorney represent them. And I think it's very important that this Michigan Supreme Court case from less than 2 weeks ago is referencing United States Supreme Court cases from well over 100 years ago, and then from over 40 years ago, that underscore the concept that attorneys are there. They're knowledgeable and skilled, knowledgeable in the law and skilled in the practice of law, but they are there to provide assistance and aid. Those are the language, those are the words that are being talked about here. It's not for attorneys to do everything for people. People should be allowed to represent themselves in a case and to decide whether or not they want attorneys. And if they want an attorney to be there in a particular case by their side to be able to offer counsel or suggestions or advice, great. But it's a side note that is not at all what this case is about, but it goes to something that is extremely important, and it's our fundamental right to be able to represent our own interests in any kind of government setting without having to have an attorney represent our interests for us. And I took that as a for granted moment until really in the last year, I've seen more and more of that pop up where people are being told, nope, you don't have access to this court, or you don't have access in this governmental setting unless you have legal counsel representing you. And that's a load of garbage. You should never be forced to hire an attorney. I also think it's important that the court points out that the dissent in the case, the parties to the case, the majority of the court, nobody was able to find any kind of opinion from the Michigan Supreme Court at any stage in history that applied attorney-client privilege or the work product doctrine to protect governmental bodies, ever. So there's no precedent for doing that. It's very important to think about it that way. And there are other cases, such as in the federal courts in Michigan, this court points out that the scope of attorney-client privilege specifically is narrower, even though it does exist for governmental bodies, it exists in a much narrower capacity than it does for, a private person. And the purpose of the privilege, attorney-client privilege, is not to protect communications which are statements of policy or interpretations adopted by an agency. So that was actually that Eastern District of Michigan case from 1979. But they're saying basically if an attorney is giving a governmental body, in this particular case, I don't know if it said, well, it was the IRS actually, but if it's giving a governmental body, a city council, a township board, a redistricting commission, whoever, right? Any kind of governmental body or governmental agency, if an attorney is giving a legal opinion to that agency is a governmental body. They can't just hide behind attorney-client privilege and say, oh, but we don't have to give this information, this legal information to the public. No, if you're going to rely on that as authority and you're going to create your policies all around this information that's given to you by this attorney, then it should be public. All of it should be public. I mean, I honestly can't even believe we're arguing about this. And another court said, and this is the Montana Supreme Court in 2018, and the Michigan Supreme Court is quoting them, that it is plain then that in a court's review of a claimed privilege, when a citizen seeks governmental information, it should not treat the privileges as sacrosanct, particularly in light of the presumption of openness the Constitution endows. And then the court continues by saying what limitations there would be in implying some sort of privilege. So, it's obvious that the Constitution is requiring openness by governmental entities to the public because we are government of the people. The government works for we the people. We don't answer to and serve the government. That's not how this whole thing is designed. And in fact, the Michigan Supreme Court is quoting here saying that as a threshold matter, the attorney-client and work product privileges belong to and benefit their public sector clients, not the lawyers. Unlike their private adversaries, state and local government entities exist for the sole purpose of serving the public. I just want to underscore that point again. State and local government entities exist for the sole purpose of serving the public. So I don't care what case you're talking about or what piece you're trying to fight for in the freedom movement, or quite frankly, if you're Republican, Democrat, it doesn't matter. Remember that. We, the people, don't answer to and we're not accountable to our state representatives and our legislative bodies and our government officials. They are answerable and accountable to us because they serve the public. In fact, the sole purpose for which they exist is to serve the public. I told you guys, this is a phenomenal opinion that goes beyond what the actual case was originally about. Unlike the private attorney-client privilege, there is no legal tradition of a government privilege. Why would there be? The most persuasive argument against extending the privilege to government lawyers is that in the public practice of law, the ultimate client might be the general public and not the public official. So think about it. They're saying that with attorney-client privilege or attorney work product doctrine, things that keep information or documents shrouded in this confidentiality, right? That when you take that and you apply it in a government setting where the attorney is working for a government agency or a government official, in the end, the ultimate client is the general public. not that particular government official. And it should always be viewed that way, because I don't care what agency you work for, what level of government you work for, how many years of service you've had. If you work for the government, you work for the people, and you should always be answerable to and accountable to the general public. So very interesting things that are in here. I mean, this thing I have blue highlighted like all over on almost every page. So let me try to pull out the most important things here. So it's also important that the court is saying that even though attorney-client privilege and work product doctrines are grounded in the common law, meaning they've been around forever, they haven't just been created by the legislature in a statute, but they've been things that the courts have recognized for years. The court says here that those privileges and protections, they're creatures of common law, and the common law must give way to the Constitution to the extent that they are repugnant to the Constitution. So again, it goes beyond what this particular case is about with attorney-client privilege or giving information to the public. But think about it. Anytime the common law, and you have anybody that talks about the common law, or they want to, rely on something from the common law, anytime the common law, which is just what cases have said throughout the years, anytime the common law is repugnant to the Constitution, to the extent that it would shield something that the Constitution requires to be disclosed, for example, the Constitution must prevail. Those are literally the words from this opinion. I think those are very important aspects. And the court says this is because public bodies work on behalf of the public rather than for private interests. And a broad application of the attorney-client privilege would impede the flow of information to the public on whose behalf the work is being undertaken. This concern would be especially acute with regard to this commission, which is unelected and unaccountable to the public through the traditional democratic process. The court then talks about what an author, Green, was talking about in this law review article, Redistricting Transparency, and quoted this part, that a common critique of independent commissions is that they take power from accountable members of state legislators only to put it in the hands of unelected and unaccountable commission members, which is true, and it's a problem and probably a discussion for a whole other day. To combat this concern, independent commissions employ a variety of mechanisms to enable public oversight and participation. So again, the mechanisms that enable that oversight and participation by the public are extremely important and can't be overlooked. So when you have a closed session, in any closed session of government, that should be frowned upon in general, but some sort of extraordinary circumstance why that would be necessary. But certainly in this situation where the whole body was literally created because they no longer trusted the legislature to do the job that they have now assigned to this body. And then it points to the Florida Supreme Court. This court, the Michigan Supreme Court, says that similar concerns have led the Florida Supreme Court to deny the Florida state's legislature the full scope of the legislative privilege against disclosure of documents with regard to materials related to the legislature's compliance with constitutional redistricting criteria. And that was a case that came out of the Florida Supreme Court in 2013. So Michigan, Florida, they see it the same way. The information should be disclosed to the public because the redistricting process in particular is extremely vital and important to the ability of the people to have their voice heard properly at the polls. If you have a redistricting problem, if the districts themselves are drawn in a way that disenfranchises voters or does something illegal or some other way wrong, then the voters have lost their vote. They no longer have the same voice at the polls, and our whole system it crumbles. That's why election integrity is so important. That's why these cases in the Michigan setup of things in the Michigan Constitution are fast-tracked right to the Michigan Supreme Court. So what's interesting is that the Michigan's Independent Citizens Redistricting Commission, this public body, it's pointing to the OMA, the Open Meetings Act of Michigan. And it's as a reason to say that they get to hide behind attorney-client privilege or to be able to have a closed session. And the interesting thing here, though, is that the Michigan Supreme Court points out that, okay, you point to the OMA, but the OMA expressly provides that all decisions of a public body must be made at a meeting open to the public. The MCL for that is 15.263 subdivision 2. So keep that in mind too. This case isn't about the OMA itself, but the OMA was brought in. And keep in mind, if you are a public body or if you are an individual who is just starting to get involved with the freedom fighting movement and you want to know more about what government bodies are supposed to do and government meetings are supposed to look like, keep in mind that all decisions of public bodies must be made at a meeting open to the public. That's the underlying thread through it all. If the only meetings that needed to be conducted in the open were those at which decisions are made, then the commission could operate almost entirely in secret, popping out into the open only to cast a decisional vote on matters discussed and deliberated on in private. So the Supreme Court is saying that even getting and receiving information and deliberating on the vote, even if the vote itself isn't taken at that meeting, the meeting still has to be in public because these are the essential elements of the whole process that need to be disclosed to the public. And the October 27th meeting, the court is saying it did address business of the commission. So therefore it had to be open to the public. So the court ordered that the recordings from that meeting be immediately released to the plaintiffs and to the public. It'd be interesting to see where those recordings are. And I don't know where the meetings are taking place. The court points out here that as the commission itself acknowledges, the memoranda that they considered at the meetings involved how to bring the maps into compliance with federal law. The commission was arguing that the meeting itself and then the memoranda that they relied on and those conversations they had with the attorneys during those meetings or that meeting, that was all, it should be protected from, by attorney-client privilege, and the people shouldn't get to know about it because the meeting, according to them, was, quote, replete with questions a client would ask his or her attorney about how to comply with the law and candid answers and guidance by the commission's attorneys. The court points out this demonstrates that the meeting involved the core business of the commission. And while such advice might otherwise be privileged as a communication from an attorney, any such privilege must yield to the constitutional requirement that the commission conduct all of its business in open meetings. Now, I want to go on and continue to share some really good information that happened throughout here, but there is a problem. And with this opinion, one of the biggest problems is that in the end, the court said, okay, that meeting should have been in public. So the plaintiffs win on that. Unfortunately, the Supreme Court only ordered that 7 of those memoranda be disclosed to the public. They're claiming that the other 3 would be protected by some sort of privilege and not required. However, the Supreme Court's own arguments here would apply to those other 3 memoranda as well. So again, I want to give props to the Michigan Attorney General because the Michigan Attorney General apparently in that opinion came out and said that publication requirement of the Michigan Constitution is broad and does not appear to contain any limitation on publication of the materials used to develop the plan. So the Michigan Attorney General's office was arguing that the meeting should have been open and all of that information should have been disclosed to the public, which I will give them props at that office for coming to that conclusion because that is correct. So basically, part of it is they're arguing, well, what's a supporting document? What is supporting material? Because it's supporting material that has to be disclosed to the public. Well, materials that advise against change or that are simply considered when determining whether to make a change can be part of a developmental process. And the whole public hearing process seems to be geared to enable change to happen. That's why you have to have all those meetings in this new process. So with regard to the memorandum, the first memorandum that the court says, no, they don't have to disclose that. The commission describes this memorandum as follows. It is attorney-client communication and attorney work product providing interpretation and legal advice with associated risks and penalties outlined regarding constitutional restrictions on individual commissioner behavior. So the court then says that this memorandum has no direct bearing on the plans or how they were formed. Rather, the memorandum deals with the individual interests and behavior of the commissioners themselves. I would say, first of all, I want to point out that the court points out in a later footnote that they took the commission's word for it when it comes to what the subject of the memorandum was, what the language of the memorandum actually entailed. So we don't know what's actually in there. The commission got to just describe the memorandum, and the court just said, okay, we'll go with that description. I have a problem with that. The commission or the court also is saying that it's talking about constitutional restrictions on individual commissioner behavior. To me, we're talking about it's either related directly to their job in that role as a commissioner on this commission or as a private citizen, in which case, why would that kind of information and advice be given to commissioners on the taxpayer's dime if it has something to do with them in their private role as a citizen? No, it's in their role as a commissioner. So what they can do, what they must do, what they cannot do as an individual commissioner, because there would be some sort of risks or ramifications or penalties because there's a specific constitutional restriction upon that commissioner to behave in that particular way. I would think that the public has every right to know what the information was being conveyed and how the commission is being told to behave. That goes right to the heart of the openness and transparency of this whole process. If the commission is being told they can post or can't post certain information on social media, if they're told they can have conversations with members of the public, or they can answer emails or phone calls by members of the public, or they're told they can't do that information, they can't provide that kind of information to the public, they can't engage the public in that kind of way, the public should know that. Because first of all, if they are being given that advice, if they can't be open about the process or provide information as an individual serving on that board, that's not true. And that should be stopped. But how can that be stopped if that can't even come to light, that that's the advice and information that they've been given? Hopefully that makes sense what I'm saying here, but I think it's bad, it's flawed reasoning and logic on that point. The other two memorandums that the court said did not need to be shared were from March 2nd of 2021 and May 25th, 2021, regarding the same litigation. So again, earlier I mentioned that the commission tried to get the Supreme Court earlier in 2021 to give them additional time and to completely disregard the timelines set by the Constitution by which they have to put these plans in place and have these meetings. And the court noted on page 3 of this opinion that the commission didn't follow the timelines at all, even though the court already said to them, guess what? I don't care your reasoning. It's not persuasive. You need to do your job according to the Constitution. They didn't. So the first of these is where the commission adopted a resolution to authorize the attorney to basically get that extension or dismissal of the deadlines in the Constitution. So the first of these is before asking, where they decided to let the attorney file this lawsuit earlier in 2021, asking the Supreme Court to give them a pass on the timelines or deadlines. And the second one is where the attorney provided the update on the Michigan Supreme Court petition and the next steps. To me, that should have been public information. If you're going to vote to give an attorney the go-ahead to go to the Supreme Court and ask the court to set aside your constitutional obligations and duties, Why should any of that be private? Why would the court even have jurisdiction? I wouldn't think the court has any jurisdiction to set aside the deadlines imposed on the commission by the Constitution itself. Their whole power only exists because of what the state constitution gave to them. And as part and parcel with that power, they have to exercise it in a certain manner. And if they can't be open and disclose information and hold their meetings in the public eye, and on top of that, they're going to miss all their stinking deadlines, and they want the court to set aside their deadlines completely, why does this commission even exist? They're unelected. There's no transparency built into this process except for all of those pieces that they are violating when they're doing this redistricting. The court said that these last two memoranda I talked about relate to specific litigation, so that the two memoranda relate to the specific litigation would not prevent their disclosure if they were materials that supported the development of a map. But the action itself did not directly involve either the substance of the maps or the actual mechanics for drawing the maps. And I would argue, as I'm sure I'm hoping somebody in this case did, of course it goes right to their job. It goes right to the heart of what they're doing. If they're saying, could you please excuse us from not doing part of our job that the Constitution requires us to do in the manner that the Constitution is requiring us to do it? That goes to the heart of the process by which this whole map is being developed. So, of course, it goes to the mechanics of drawing up the maps if they're not doing it in the way that the Constitution tells them they have to do it. I don't understand the philosophy or the logic behind the court, in how they came to that conclusion. I don't understand. So I would completely disagree with the court on that, especially when you look at earlier, court talked about People v. Whitney. It's a Michigan Court of Appeals case from 1998, and it quoted that case as saying, it would be illogical to construe the attorney-client privilege exception to the OMA as authorizing a public body to evade the open meetings requirement of the OMA merely by involving a written opinion from an attorney in the substantive discussion of the matter of public policy for which no other exemption in the OMA would allow a closed meeting. So you can't just say, well, the attorney provided us advice on part of this, so now we get to go into closed session, or now we get to withhold information from being released, which would actually be more of a FOIA issue than an OMA issue. But in return, in terms of having the meeting open to the public, even the court as early as 1998 has said, it would be illogical to say you could just make something privileged for the government and against allowing the public to know about it simply because you had an attorney involved giving information and advice on it. Well, then why apply that information or that logic to the two memoranda that came about the case, especially the one where the court said, no, we're not going to give you a pass. The litigation is essentially over. Where do you appeal it to? You can't. It's the Michigan Supreme Court. So I don't understand why that thought process doesn't then convey to the rest of the memorandum, especially the one that then talks about the individual commissioner behavior and the constitutional restrictions against that. Again, just because the attorney is giving them that information or that advice doesn't mean that information should be privileged. No, the public has a right to know how governmental, agents or elected officials or unelected bureaucrats, such in this case, how they're being advised by legal counsel to act. They have a right to know what that advice is. But anyway, as part of this flawed logic, what's interesting is that the court says that courts generally have construed open meetings, open files, whistleblower, and similar statutes as subject to the attorney-client privilege, recognizing that otherwise governments would be at an unfair disadvantage in litigation, in handling claims, and in negotiations. Now, I would say there's a couple of problems with that. Number one, they're bringing in and talking about applying attorney-client privilege in the context of like open meeting statutes. No, this isn't a statute. This is the Michigan State Constitution. It goes above and beyond what any statute or common law tries to do. In fact, if the court pays attention to their earlier wording, common law and statutes have to yield to the Constitution. The Constitution is what goes above and beyond overall. But also, it says that this is because the courts have recognized the attorney-client privilege for government bodies, because otherwise governments would be at an unfair disadvantage in litigation, in handling claims, and in negotiations. Quite frankly, no, that's not the case, number one. And number two, I don't care if somebody thinks the government is at a disadvantage when it comes to arguing against giving information to the public. When you have litigation against a government entity, and yes, I've been involved in several occasions to sue or be part of another's lawsuit to sue the government for hiding information or having a closed meeting when it should have been open or something of that nature. In the end, again, we should look back to that other comment I read earlier, that a government attorney, the ultimate client in that sense, is often, and I would argue always, the general public. It's not that particular government agent or official. It's not even that government body. No, because that government body or that government agent or that government official's ultimate job is to represent the people. And the people, the general public, have a right to know the information involved. There should be no secrets of government for the purpose of it's an unfair disadvantage in court when somebody in the general public, when a citizen sues the government. I don't care. The unfair disadvantage is to the person who had to bring a lawsuit in the first place because the government isn't doing its damn job. The unfairness comes about when people are having their freedoms squashed and trampled on in a variety of aspects because the next up government official or the next up governmental body that has oversight, or even the courts involved at every step along the way, just give them a pass and say, no, I'm not going to get involved, or no, I'm not going to stop them, or worse yet, they say, oh no, they're allowed to totally trample your rights because of COVID or because of attorney-client privilege or whatever the garbage is that they're throwing at us these days. Our rights are being trampled upon, and we, the people, are at a severe disadvantage in litigation and in everyday stinking life because the government's allowed to just do whatever they want for whatever reason and get away with it. I don't care if they're at a supposed disadvantage when a citizen finally has the gumption and the wherewithal and the resources to bring them to court to put a stop to it. They should be at a disadvantage because they don't exist as an entity all unto their own with their own private interests to protect. Their interests should be in the same exact alignment with the public, the general public in the first place. The government's job is to protect our interests, to protect our freedoms, which brings me back to that constitutional provision that I brought up earlier, the preamble of the U.S. Constitution, the preamble of the Florida Constitution, and certainly and most clearly stated, the preamble of the Michigan State Constitution. The job of the government, the whole reason why we have a constitution is because we are grateful to Almighty God for the blessings of freedom, and we earnestly desire to secure those blessings undiminished to ourselves and our posterity. So we are ordaining and establishing a constitution, a system of government by which we will all agree to participate in, a system that has to be followed per the Constitution, not these rules that they each get to make up on their own agencies. No, the system of government put into place by the people through the Constitution to protect our liberties, our blessings of freedom that are given to us by God. So to me, that is what underscores this all. So overall, this case was a big win for freedom, but and there's some great things that the court points out here, but it's still a loss because it missed the mark on those three memorandum which who knows, maybe themselves they wouldn't have done much of a difference for the public to know about, but we won't ever get to know. I will close this out by saying, the court reminds us in their conclusion that the voters in 2018 changed the process for redistricting in Michigan. In doing so, they established numerous safeguards to ensure that the new process would be transparent, as all government should be. Today, we enforce two of those provisions against the commission's attempt to operate outside of public view. And so they are ordering that the records of that meeting be disclosed to the public and that the 7 memoranda be disclosed to the public. In fact, all documents and other materials must immediately be turned over to plaintiffs and be made public. And the filing of a motion for rehearing shall not stay execution or enforcement of this judgment. It is very important that the court said that, because obviously the government, or the commission in this case, is going to try to stall and file a motion for reconsideration and everything else. And that can sometimes put a pause on the judgment of the court. But this court said, no matter what else you're going to ask us to do, this is effective immediately. Under no ands, ifs, or buts. You must give the information to the public. And it's interesting, too, that the court notes that the language of the Constitution, this is the language of the Michigan State Constitution, the powers granted to the commission are legislative functions not subject to the control or approval of the legislature and are exclusively reserved to the commission. And I guess for that, I want to point out that the U.S. Constitution guarantees us a Republican form of government and sets out that framework that legislative functions are to be performed by legislative bodies, elected legislative bodies. It is not a Republican form of government to have an unelected body, in plain language, perform legislative functions. It's just not, it's not appropriate. So that amendment to our state constitution itself is unconstitutional. But also it's interesting and something to keep in mind. The dissent was emphasizing the number of meetings and hearings that the commission has held, and the majority said that's beside the point. No number of open meetings and hearings can make up for the commission's concealing that which must be disclosed. That's a very important point. If you do something wrong over here, if you don't give us information, you hold a meeting in public, in private, whatever the case may be, you can't just remedy that by giving us this other information or holding these other meetings. It doesn't matter. All of it must be open to the public and disclosed to the public. It's also very interesting that, and the court says, it is worth noting that the drafters of this constitutional provisions, voters, not politicians, apparently do not agree that the commission would be have their job, taken away or kneecapped by disclosure by all of the requested information materials. They quoted the Voters Not Politicians' own website that says, voters established the commission to bring redistricting out into the open. Anything that informs the commission's mapping decisions should be made public. So that's a very important point. There's some other stuff that would be important to note later on. But again, I think one of the most important pieces here, there's two. One is that the court says our constitution, our state constitution, is unique. And our obligation, the court's obligation, is to protect and defend the Michigan Constitution. That should say it all, with regardless what kind of case we might talk about in the future, with whatever may happen with any kind of government entity. The court should always remember their job is to protect and defend the Michigan Constitution. That includes deciding to hear cases that they might otherwise say, well, we don't really want to hear this case. And also that the dissent was arguing that all of this was happening very quickly and that it shouldn't have happened this way. It was happening in haste. But the court points out that this is an emergency case and they heard it and they decided it on an expedited basis, which only serves Well, if they had delayed it anymore, that delay would only serve to hinder the public's ability to consider the materials before the impending close of the public comment period, which is December 27th, just a week or so ago. In fact, the court said, we have not acted in haste, but instead we have worked to ensure that the public's constitutional right to this information is vindicated in a timely and meaningful manner. So again, it is super important to keep that in mind and underscore that the public always has that right to information. And whether we're talking about the Open Meetings Act or the Freedom of Information Act or the Constitution itself, there's stuff out there that there's hope to be had. I'll put it that way, because it's definitely a done deal that the government is there to serve the public, and the information that they rely upon in doing that job is something that should be disclosed to the public.